for installing this Peggy This is Karl Keller. Case number 18CA0012M. Both sides will have 15 minutes to present their arguments to the court. Opponent may reserve up to 5 minutes for rebuttal argument. And the only other thing we need to say is we've read the briefs and are ready to proceed if you are.
I would ask for 5 minutes for rebuttal time.
Keep your person.
And well, may it please the court, opposing counsel Donald Gallick on behalf of defendant appellant Karl Keller. Just as a preliminary matter, I have this supplemental authority in the Keller Appellate Rule 21, I think, that I was just handed me. I don't object in using it, but if the court asks me about this case, I have no idea because I've seen it all in 10 seconds. There's 4 assignments of error presented to this court. This court knows this is a 7-year-old real estate dispute. 2 of the assignments of error go directly to that partition action. The remaining 2 go to the counterclaims that we had a jury trial on that ended in a directed verdict. Obviously, the real estate matter is more serious. You had a $400,000 house. It's now gone. This court didn't stay the judgment this time. I think this is our 4th appeal. I think it's our 4th appeal. That $400,000 house, I believe, sold for about $170 grand. So we're all losers here. No matter what this court does, everyone on all sides has lost tremendous amounts in this case. There's nothing to be done about it at this point. Having said that, you have a stipulation where the trial court acknowledges during a 60B hearing, oh, you're right, you didn't, talking to Karl Keller's counsel, you didn't understand what the stipulation meant. I believe the trial court's statement was, you were in the dark as to the consequences of the stipulation. Mr. Keller submitted an affidavit saying, I've never been married to Peggy Hack. This deed is fraudulent. She's not a joint owner. I didn't stipulate that she was a joint owner. So you have something where Mr. Keller didn't know anything about this stipulation. He doesn't agree with it. Mr. Keller's counsel said, I didn't understand how the stipulation worked or what the stipulation effect was going to be. The trial court acknowledged that the stipulation was a unilateral mistake and yet refused to vacate it. And so you didn't vacate the stipulation, so they've been joint owners of this property for 7 years. By law, we would say erroneously, but now the house is diminished in value by, $400,000 to about $170,000, $180,000, and the house is gone. Now we have these funds that we're fighting over. Is it an abuse of discretion not to vacate a stipulation where the trial court admits, counsel, I know you didn't understand the stipulation. Oh, it looks like your client didn't know anything about the stipulation, but we're not going to vacate it. We're just going to stick you with this stipulation, even though neither one of you knew what was going on. Those go to those 2 assignments of error. The case law on this, I don't think we have a good Ohio Supreme Court case law on it, but I cite the Vengro opinion and a couple other things, and even some criminal cases where they say, if it isn't knowingly and voluntarily entered into, almost like a criminal Rule 11 colloquy. If you have a stipulation where the client didn't know what was going on, didn't understand what the stipulation is, it shouldn't hold. And we think the court should apply that law here to the 60B motion. Regarding the other 2 assignments of error, you have conversion claims. There's an unjust enrichment claim. I see it more as a conversion claim. I did not draft a counter claim. I've only been on this case about 4 of the 7 years, something like that. You have a directed verdict issued under Civil Rule 50. The jury's sitting in the box. Ms. Hack's getting ready to testify. The trial court says we're going to grant a directed verdict. Why? Well, because Mr. Keller didn't know the exact value of the property that he claims Ms. Hack really stole. Conversion, theft, call it whatever you wish. I cited case law. This very court said in 1942, I don't know if any of the judges were here, I wasn't here, in 1942, that the Ohio rule, you don't have to know the precise issue. This person right here, they stole my hat. How much was your hat worth? I don't know, $5, $10. That can go to the jury. The jury can decide. Mr. Keller testified, my tools are missing. I think they're worth $80, $100. I had a giant jar of silver dollars worth about $100 a piece. How many were there? Well, there's this many. A jury can opine on that under Ohio law. The trial court said no, they can't, and we're going to grant a directed verdict. There was also the issue of, was there a demand for return? Mr. Keller suggests that there was, but there wasn't anything in writing. And there's also statements from Ms. Hack that they come in through admission by party opponents, and she didn't get to testify, the Civil Rule 50 issued before she could testify. But Mr. Keller said, he asked, hey, where's all my property? Where's all my coins and my tools and all these other things? And what Mr. Keller testified to in court in front of the jury is that Ms. Hack said, maybe you put them in a pile of manure. Now, is that probative that maybe Ms. Hack had something to do with the disappearance? I mean, if you said, I'm looking for my car keys, Mr. Gallick, did you take them? You know, maybe you threw your car keys in a pile of manure. Does that sound like maybe a statement of kind of animosity or something where maybe you need to investigate me a little bit more, maybe I had something to do with your missing car keys? That's a jury issue. And the jury might have found Mr. Keller's testimony completely unbelievable. Or maybe the jury thought that Mr. Keller's testimony was, yeah, it makes a lot of sense. And Ms. Hack is getting ready to testify, and we'll know even more facts when she testifies. No, the trial court issues a Rule 50, Civil Rule 50 motion, and the jury goes home. That's reversible error as I see it. I cite various law on what conversion is, again, going back to 1942 and more recent cases, saying that you don't have to know the exact issue or the exact value of the property that's been converted. And the demand and refusal, you can look at facts inconsistent with ownership, such as, Mr. Keller testified that he had a bag of receipts and he believes Ms. Hack or her son stole those receipts. That's in the trial transcript.
Did the court also hold that there was no evidence that Mr. Keller made a demand for the property?
Well, no, that did come out. But I mean, there's been 7 years of litigation. I mean, if you get a lawsuit, you get a lawsuit saying, hey, I think you took my car keys. I think I can prove by a preponderance you took my car keys. I'm suing you. That's a demand and refusal. I mean, if you come into court and say, here's your car keys, I apologize, sir, I took your car keys, case dismissed or whatever, there's no question that Ms. Hack believed there was a dispute from this. And Mr. Keller did testify, hey, where is my missing property? I mean, if you say, well, that's not it wasn't in the proper form of, I hereby demand that you return the items that you committed conversion against. People don't talk that way. Hey, where are my missing items? Where are my coins? Where are my tools? Maybe you should look at a giant pile of manure. That was Mr. Keller's, that's his testimony. That was the response when he said, where are my items? Is that a demand and refusal return? I think, again, that's enough to go to the jury. It meets the burden of production. And certainly the lawsuit is a demand for these items. It was in the counterclaim filed in 2011. If there's no further questions, I would ask to reserve the balance.
I was just going to say, in regard to that, though, filing the complaint could not be regarded as a demand, could it? That seems to be what you're arguing too.
Well, I think asking about the property and someone telling you to go dig in a pile of manure, I think that would satisfy enough for the jury. And maybe the jury doesn't see it good enough. They say that's not good enough, or maybe it is. But as a matter of law, I think it meets the burden of production. The complaint certainly puts you on notice that there's a dispute over these items. I mean, if Ms. Hack were to say in her reply to the counterclaim, I don't have the property was taken by whatever, or I'll return the property next week or whatever, this would be resolved through a settlement conference, at least these claims.
Well, yeah, but you'd have the issue of court costs and so forth.
Well, and we would all be lucky if that's all we were fighting over.
I understand, but I'm still trying to, I have a disconnect, I guess, from the law saying that you have to make a demand before you file suit, I guess,
Well, and Your Honor, you could certainly say the complaint doesn't satisfy that requirement, and asking about your missing property and someone telling you to go dig in manure, that's not sufficient to meet the burden of production. And I mean, that is a question for this court. And if you say, no, that's not good enough, the jury shouldn't have been allowed to hear the case based on that, meeting this demand and refusal. But, the journal entry has no legal reasoning. All we have is a statement in the transcript where the trial judge says there was no demand or refusal, and you don't know the exact value of the items, so we're gonna throw these claims out and send the jury home. Definitely, I think the precise value, that's not needed under Ohio law, and I think the complaint could be put you on notice. At a minimum, where's my items? Go dig in a pile of manure. I think that meets the burden of production with the jury sitting right there. The directed verdict should not have issued. If there are no, please.
No, I'm just wondering, what your response would be to the untimeliness under 60B1, since your argument seems to be mistake, inadvertence, neglect by the attorney.
Well, that the 60B should have been filed a lot sooner?
Yeah.
Is that, well, I mean, that's an argument. I do not, and again, I was not present at the motion to vacate in 2014. I think it was April 2014. I don't know if that was an issue for the denial. I cannot remember if that was in the journal entry. I mean, that would be a new issue. I thought the issue was the trial judge just said, you know, they were scheduled for trial. And the trial judge correctly said, why are we going to have a trial on the partition if both sides have stipulated that it's a 50-50 part? And then the issue comes up, oh, wait a second, you mean we can't challenge that she's a joint owner when we stipulated that she's a, you know, you stipulate that she's a joint owner, and then you want to have a trial saying that she doesn't, instead of 50%, she should get 0%. That doesn't make sense. The trial judge is correct about that. That's when the 60B arose. Like, oh my God, I didn't realize that's what the stipulation was.
But counsel, in that same vein, there was a magistrate's decision giving everybody notice of what the court's decision was about the impact of that stipulated entry, and then no objections to that magistrate's decision were filed.
Your Honor, I can't, and if the court might have the docket sitting in front, and I do not, so I'm at a disadvantage in this lengthy litigation. But if that's true, if the issue of waiver forfeiture is why the stipulation was denied, if that was in the journal entry, I missed it. I don't remember that being the issue. Perhaps that's something sua sponte the court can look at and say, but I don't think the issue was the motion to vacate was untimely, or there wasn't an objection to a magistrate decision. If there was, then I apologize. But I remember this being denied basically on, we have this thing set for trial and we're not going to do any more litigation, which led to years and years of appeals.
All right, you're at 3 minutes and 30 seconds, so.
I'll thank you for your time.
Good morning, Your Honors. May it please the court, I'm William Young, counsel for Peggy Hack in this matter. Before I proceed, I congratulate Your Honor on her re-election. Opposing counsel is correct. This case is 7 years old. I have a 6-year-old granddaughter that wasn't even born when this thing started, and it has found its tortuous way throughout this legal proceeding. And it's all because of the appellant, Karl Keller. We filed the original complaint for partition. He filed a counterclaim for partition. So to come in and say he didn't want that is clearly not the case. And additionally, I don't know where counsel came up with a $400,000 house. The commissioner came back with a value of $270,000. It couldn't have sold for the amount that it did in violation of the statute, so clearly the $270,000 figure is the applicable one here. And of course, my client suffers the same loss that his did. So why are we here? What was the problem? Well, the problem was Karl Keller's counsel. We prepared a joint stipulation. The court did not have anything to do with the drafting of that stipulation, and the stipulation was that the parties agreed that the property should be partitioned. That was signed by both counsel, myself and Mr. Keller's counsel at the time, and submitted to the court for the court's perfunctory approval, which it did. And then later on, he decides that he made the mistake of thinking that it would go his way, when in fact the magistrate, as you point out, told him that it didn't go that way. And he waited 18 months from that time without ever objecting to the magistrate's decision in that regard, to then come in and say, oh, I made a mistake, I really thought something else. What did he think? What he actually thought was, he said, my belief was that the sheriff's sale would be held and the money would be held. That's exactly what happened. So he didn't even make a mistake. And now they're coming into this court and saying that he made a mistake. Well, his mistake was in agreeing to the stipulation, if that's what he didn't want. But that's something that has to be imposed upon the appellant here, and not upon the innocent party, my client. This has happened over and over and over again, where a party who consents to an entry is held to the consequences of that entry. Judge Teodosio, you just issued that decision, which I have supplemented to the court here back in March of this year, where any consent entry is a waiver of any argument you have with respect to that entry, and we have to have that finality. This is why we're here for 7 years. Karl just keeps filing appeals, filing motions, or ignoring the timeliness of them. And that's critical in this case, because if it were in fact a mistake, he needed to bring that to the court's attention within 1 year of that mistake, which he did not do. It was 18 months. And we need to have some rules with which to abide by. I remember my class in pretrial procedure where our professor said, these are not suggestions of civil procedure, these are rules of civil procedure that you're required to abide by, and Mr. Keller should be required to abide by that time limitation. Additionally, I find it interesting that in his brief, in his argument with this respect, he cites no authority, no case law, no statutory authority whatsoever for his position in that regard, and yet he's critical of the judge's directed verdict entry for the same reason. Yet the judge told him exactly why, and in an open court, he told him exactly why. So I don't know how much more he needs to do, particularly when we're dealing with a de novo review by this court. So regardless of the decision that the trial court made, this court needs to look at the record itself. And if he made a mistake, certainly this court could have corrected it. And I don't know how many times I've seen a decision where the court said that, well, yes, the trial court made a mistake in its decision, but the ultimate result is good, and we're going to affirm that decision. I find it interesting that a lot of the time spent in this case is with respect to the conversion case, and yet they admit that the important part of this whole thing is the vacation, the attempted vacation of the stipulation. The property has been sold. At this point,
have the proceeds been distributed?
no, they're being held pursuant to court order.
Sold at foreclosure.
In a similar fashion to foreclosure, yes. The sheriff conducted the sale. So we get to the conversion issues, and the court advised the defendant that yes, you failed because you failed to make a demand and a refusal, and Judge Karl, your point is well taken, that if that rule were not in existence, then you don't ever need to make it. You just put it in your complaint. Well, that's, at that point, we're already talking of litigation, which could have been avoided had that demand and refusal been made. More importantly, I think, this definition, or excuse me, the argument with respect to damages is mischaracterized, I think, by opposing counsel. Every time Mr. Keller was asked about the value of any of his property, his answers were typically, we asked, what's it worth? I can't tell you, I don't know. How many silver dollars? I'm guessing 50, 60, I don't know. Can you give me an idea? Can you give the jury an idea of what value of these containers were full of coins? That's pretty tough to answer. I don't know how much money to get in a gallon jar. I can't tell you. Over and over again. We have that discussion on the record. What's the value of these attachments to the window? I don't have a clue. What is the value of the lid on the propane tank? I don't know. It's never been replaced. I have no clue. So when I asked him, do you have any idea what these are worth? And he's saying, well, I'm going to guess. And I asked him, well, don't guess. This court knows you're not allowed to just start guessing. You have to have more than that. He said, no, not really. I don't have any idea. So this court, back in 1990 in the Dracillus case, required that when you try to present evidence for damages for personal property, it isn't awarded based solely on the answers or the owner's testimony where he has no evidence of its age, its condition, its replacement value, or its original cost. We saw nothing of that. And instead, what we're opposing counsel is attempting to focus on is a pile of manure. That's insufficient. And with respect to this issue of having no legal reasoning, I think I've already addressed that, so I will not pursue that any further. But to say that...
Did he have to put his reasons in the entry to comply with 50E?
I don't believe that rule requires that. In fact, it makes reference to the fact that it could be complied with by making the announcement in an open court. And if he insisted on having those, it is incumbent upon him to make that request of the court prior to filing a notice of appeal here. He waived any argument of failure to include the basis of his decision in that judgment entry. That's according to the Darcy case cited in my brief. So at every step of the way, what we really see is Karl Keller attempting to pervert the prompt justice of determining this partition action. This case should have been decided and resolved long, long ago. And if this court were to agree with his position that because his attorney mistakenly thought that his stipulation would become a different result, as I mentioned in my brief, that's going to open a whole Pandora's box. Every lawyer could come in and say, well, you know, I made a mistake. I thought it was going to go one way, and now that it's going the other way, I want to come back and undo it. And even had he had that position, he waited 18 months, way too long. So this court, I would submit, should respectfully affirm the decision of the trial court in all respects.
Is there a distinction between an agreed entry that the parties, actual parties, sign or indicate approval in open court and a stipulated agreement between counsel?
Absolutely, and in fact, I'm glad you mentioned that, Your Honor, because the cases that are relied upon by Mr. Keller are ones in which the court utilized prior written stipulations prepared by the parties and then attempted to incorporate those into the court's decision and did so mistakenly. In Venegro, they left out some of the materials, and in the other case, they mischaracterized them. Here, we don't have any of that. The court didn't touch that stipulation. It went in as drafted by counsel and as approved by counsel. All Judge Collier did was sign the entry. Quite different.
And you don't think it was necessary for the court to bring the parties in and say, here's the agreement of counsel, do you concur in this agreement? Or to require a signature line?
There was a signature line. Both parties.
Both parties, not for
Both parties. Oh, well, in that case, we should have it in everything. Is the court going to involve the parties in everything? There are numerous cases out there that say counsel's decision for a party is going to be the burden of that party. And if they have any recourse, it's recourse against their own counsel. Don't visit the sins of the defendant's counsel upon the innocent plaintiff.
Thank you.
Thank you.
Any questions? Thank you. You have 3 minutes and 32 seconds.
I'll try and cover this. His prior counsel, Steve Bailey, said he didn't understand. I just figured out what the stipulation means. We're filing a 60B. I don't know. Maybe he has credibility, maybe he doesn't, but that's what he said. It's in the transcript. Regarding the demand and refusal, I cited case law such as Davis versus City of Canton out of the 5th District. I cited a 10th District case and also an 8th District case where they say demand and refusal, but sometimes maybe that's not necessary. Maybe you can just look at the behavior of the defendant acts inconsistent with ownership. Karl Keller testified that Peggy Hack, when this property dispute came about, she changed the locks on the house. So they both, their stipulation that their counsel applied, that Mr. Keller said he didn't understand, that they're joint owners, for a period he's locked out of the house. He thinks that's when his property vanished. Could that be an act inconsistent with ownership? You tell your alleged co-owner, digging a pile of manure and changing the locks, and don't ask me where your property is. Regarding the findings of fact and the 50E, this was a judge overseeing this jury trial. So I don't like the final order that the judge puts out. I file what? Findings of fact, wait for 30 days, and then I file a notice of appeal, and then this court says, well, you're filing over 30 days from the final judgment. The appeal's dismissed. You've lost your right to appeal. I don't think this court wants to say that we should be filing essentially motions for reconsideration of a trial judge overseeing a jury trial, granting a directed verdict. The judge waits 45 days, says, I'm not reconsidering anything. I'm not issuing any new finding of fact. Read my journal entry. Now the notice of appeal is untimely, and there is no delayed civil notice of appeal. So where are we there? Some of the law is a little, there's conflicts regarding demand and refusal and the valuation of the property on conversion, but there's some law cutting our way and there's some law going the other way. But obviously, from a dollar and cent standpoint, the stipulation and the real estate is what matter. I think this house was worth close to $400,000 10 years ago, 12 years ago, something like that. I might be mistaken, maybe it was in the 300s. But yes, there's about $170,000, $180,000 sitting in Mr. Young's IOLTA that will be divided at some point by someone in some allotment. Your guess is as good as mine. If there's no further questions, I thank the court for this very difficult case.
Okay, thank you both for your presentations. The court will take this matter under advisement as well, issue a decision which will be mailed to both of you on the day it is released. Court will be adjourned now until November 15th.